Watu watatu kwa mbele. Umeshatoka.
Second count have a foundation in the penal code, while count number 3, 4 and 5 has a basis in a different statute, the Anti-Corruption and Economic Crimes Act. The first offense is that of uttering false document under section 351 of the Penal Code, while the second one is for perjury under section 110 of the Penal Code. Our entire criminal justice system. And Matigo said this under paragraph 35, that this amounts to sentencing a person to slow death. That's what his words are. At paragraph 39, Justice Mativo cites Chief Justice John Marshall and says that courts are not mere instruments of law and can do nothing. That's what he says. And all of this judgment has very compelling force. That is a consideration. So you are not guided by these considerations. Our humble view is that in respect of the offenses set out in the Penal Code, the first accused does not deserve a custodial sentence. She deserves something different. The first accused is 79 years of age. She's probably older than all of us gathered here today. And all she would deserve from us is fairness when we are to adjudge her. Ms. Gateru told us last week that in spite of her age, 79 years, she is a first offender. That means that for all her life, this is her first encounter and interaction with the criminal justice system. I'm sure most of us will be lucky to have such a testimonial at 79. She has spent all her life until retirement, Your Honor, in public service. Rising to be the first woman to head a parastatal at some point. This is not an effort to discard when sentencing her. But it's only part of the decretal amount that had been challenged through the criminal court. In fact, Your Honor, there was an excess of 2.7 million, even in respect the amount disclosed in the charge. The accused person has informed me, and indeed I am aware, that she is quite remorseful . Your Honor, she informs me that she is also deeply regretful she regrets that she tendered for the supply of 40,000 metric tons of maize. Had she not done that, we would not be here today.
Majorly, the income for the second accused is his salary and allowances from the National Assembly. The only try we made in terms of business was with the third accused, which was a cropper, on account of issues that it has had and the brush with the law. And therefore the only source of income for the third accused is his salary. And that makes me submit to address one issue that he never addressed you on. Especially, let me just maybe make a mention that in the sentencing policy, kindly look at 7.2, 7.6, second accused an opportunity to serve. I invite you to section 175(3)(b), Roman 1 and Roman 2 of the Criminal Procedure Code on the compensation. And this case is conjoined with some arbitral proceedings, which proceedings are pending before the Court of Appeal. And much as Section 193A allows for concurrent proceedings, Your Honor, we kindly urge you to consider that the issues that are of criminal nature here are the very issues that are before the appellate court for determination, even when they are These are criminal proceedings and the other are civil in nature.
Goes to prison, the risk becomes twice. He's already exposed to a serious risk by his age now. If he goes to prison, we are now enhancing the risk double. We argue that he should not be condemned to a slow death that Justice Mativo has said in that case. That was slow death. This might be a sure death out of corona, and the long duration will be there. I have just been told that here seated before you is a man who saved the late President Moi in the 1982 coup. That is his contribution. That is his star. A man who, when his time comes for eulogy to be read, it will be said that he saved the head of state from an impending coup in 1982. Your Honor,
Which year is that?
1982, the famous coup of Pancras Ochuka. Yamete was not born that time. 1992. Your Honor, as you take to put down the sentence, put the sentence in light of the time of the offense, not in the time of today that he's a member of parliament. Lastly, there
raises several constitutional dilemmas because it's a case that touches on all the arms of government: the legislature, the executive, and the judiciary. So you are in deciding it and taking into account the exceptional circumstances of their age, this is a case where you can make a point of departure from the normal judicial sentencing. Fourthly, Your Honor, and this issue has been raised, but I will just touch it, the principle of the guard against double jeopardy. Your Honor, read the charge sheet. In count 3, count 4, and count 5, the 3 accused persons are charged, and then the particulars are saying being directors of the third accused now jointly and fraudulently acquired public property. So Your Honor, we are in this constitutional dilemma where if you punish the first and second accused by a necessary implication, you have also punished the third accused, or vice versa. So,
Number 2, I'm holding brief of cattle for the victim.
So is the Assembly an employee of CSO or an advocate for
I'm an advocate but working with GCC.
Has he been involved in this case? No, he has not.
I have been involved in this case, Your Honor. If you recall, I've been involved in this case.
For this sake, I'm just wondering, but for the sake that the perhaps the complainants, I will allow you very, very brief time, but otherwise you are not entitled to. You could have quickly consider with the prosecution and see what they say. Otherwise, counsel only watching brief, we do not have rights. It's only with the legal.
Your Honor, kindly, what I was raising, he is an employee of the ESCC.
Yes.
He talks to the DPP. He can't address you. He could have requested another advocate to hold brief for Mr. Kato.
So he's a party.
He's a party. Is he appearing a party as an advocate, or is coming as a party who is interested in this matter? Because that is what we want to know, whether he'll address this court as an advocate, as counsel,
You know, while still on it, we're wondering with Mr. Reni in what capacity he has appeared in this case before, because the two of us have been here all through, and we are here to appreciate when he appeared, for whom he appeared.
That is Mr. Mulay.
Yes. Yes.
I am also asking, but also there is a new defense team that has come on board, so I think we cannot ask that question only on one side.
The court captured that the state might be intending to charge my client again over issues. Because if there is activism,
I'm Gary, but yes, sir. But I was just saying as a point of clarification. So therefore, under that principle of accountability and transparency, when the court is meting out a sentence, saying, so when the court submitting on the issue of the accountability and transparency, so therefore it is a submission, Your Honor, that every person should be accountable for their acts. And therefore, Your Honor, it is a submission that under section 48, 1 and 2, and looking at the amounts that are involved, the court should consider that there ought to be accountability that has to be seen. And Your Honor, one of the purposes of a sentence is it also acts as a deterrence, so that those who would think, would want, who have the desire to put their hands into the cookie jar of the public funds will desist. And the fourth one is inclusiveness. And it is a submission that the court should consider all these factors and the seriousness, inclusiveness, Your Honor. Your Honor, we are submitting that the victim here is the Republic of Kenya. Your Honor, and in particular the NCPB, which the purpose of why it was created is to ensure that there is food security in this country. You know, you cannot turn a blind eye on what availability of food means to each and every one of us. And therefore it is a submission that a threat to food security is a threat to humanity. And that these particular funds, they were meant to ensure that at no one time will our country experience food shortage, more particularly now when you're dealing with this pandemic of the corona, where many Kenyans cannot even put food on their table. And that's why we're emphasizing that these offenses should be treated with the seriousness they deserve, Your Honor. 80 years, over 60 years, who have medical conditions, but are in these prisons. Is it that other Kenyans should be treated specially? And therefore that mitigation, Your Honor, it is a submission that it didn't meet the basic threshold for the court to be swayed. And lastly, because we just don't take a lot of time, is you're talking about economic crimes where monies have gone out, and therefore the court is considering to find should look at the fine that has been imposed there vis-a-vis the money that we have lost, or the money that this country has lost. Therefore, it would be so obvious that if they are fined a figure of not more than 1 million Kenya shillings, it is so simple. They'll just go and pay it and go.
Try to be very brief. Allow me to address you first on the question of the application that was made that this court calls for the sentencing report. And I wish to say this in response. Section 216 of the CPC only applies where the court suo motu deems it fit to call for evidence. And the reading is clear. The court may. No party is given a right under 216 to petition for calling of evidence. Therefore, that application has no legs to stand on and should be dismissed in limine. You know, a reading of section 211 the medical report of 24th September 2017.
That is the medical report?
Yes, that have been the one for 24th September 2017. The dates are somewhere at the corner. They are not very easy to pick out. But you will see them at one of the, I don't know whether right or left hand.
Oh yes, 24th of September?
Yes, 2017. You wanna note the following, that report is not signed. It bears no stamp, and it is a photocopy. So is the report of 5th of October 2017. The report of 23rd September 2017. Precisely. So the point we are making is this. The risk that the court would run is reliance on material that is unverifiable and that could very easily be conjured up material. And the court must reject those documents, even as we are being asked to consider allowing other evidence to come to this court. The next point I wish to make, connected to those documents, you realize all the reports are for the year 2017, split by a month, September and October. There is no medical report that is current that can demonstrate the state of health of the second accused before you. Your Honor, the second accused has religiously appeared before you. He has religiously appeared in Parliament, and he has religiously participated in community affairs, as you have been told by the defense. That is not a person in bad health. Even more important, when he was charged in this court in 2018, this question of ill health, assuming one was for a moment to believe these reports are genuine, it never featured. It has never been a question. So you are dealing with a man who is as fit as a fiddle.
Friendly, so that I don't become vexatious in these submissions. Council has alluded to a fact that there is no latest report. Unfortunately, during the mix-up, and my colleague had these, because we were several of us, there is a report, a current report, so that we don't have to. Yes.
I apologize, Your Honor, for that.
Yes, Your Honor, here is a document from one Dr. William Sigila, and I make the following observation. It was made on 22nd of June 2020. I'll ask the court to note that date very carefully. This was the date of judgment. So central. So that it is not accidental that this document featured at that stage. And in our humble submission, it is of no evidential value. It is yet another unreliable document. Your Honor, allow me to address you on the question of sentencing policy, because my learned friends belabored that point, and they invited you. In fact, Mr. Cliff Ombeta made me break my ribs in laughter when he invited you to look at section 35 of the Penal Code. Your Honor, our humble prayer is for the offences charged under the Anti-Corruption and Economic Crimes Act, the applicable law in sentencing or punishment is that act. And this you will discern clearly from the long title of the act, which reads, very briefly, an act of parliament to provide for the prevention, investigation and punishment, and I underline punishment of corruption, economic crime and related offences. Therefore, the regime of law for punishment of corruption offences is housed in this act and no other. Why is this important? Section 35 of the Penal Code was still in existence when Act number 3 of 2003 was enacted. And therefore Parliament must have intended to remove the punishment of corruption from the provisions of the Penal Code. Nothing would have been easier than for them to say otherwise. And luckily the second accused was a member of Parliament in 2013. He has been sitting there. They have never seen the need to amend the law. And there is no appearance of class application of the law. You have been told that the second accused is likely to lose his seat of parliament. So what? There are many other people in Sirisia who qualify to hold that seat.
Your Honor, that I hope that statement is not recorded.
No, you submitted on it.
Yes, so what? That is not the language of this court. Honestly.
I withdraw the words so what?
Yes.
But the supposition that somebody is likely to lose a seat of parliament in our humble submission should not persuade this court to look into the high with some degree of mercy that many other Kenyans would not enjoy before these courts. Winding up, the question of the COVID-19, if Your Honor, as my line friends suggest, that nobody should be sent to prison, then I think we would not be trying anybody in our courts today. Because basically that is what the argument seems to suggest. Because it would be pointless to try one class of persons, we send them to prison, but others, when they come, we say they are too old to go there. You know, that can never be the policy. Either the judicial policy or the policy of government as a whole. You have been urged further, as you sentence these three, to consider what portion went into each one of them. But the law suggests otherwise. Look at the loss or benefit suffered. It does not talk about apportioning. It cannot be on a pro rata basis. Appeal nor any other person shall use, apply, or in any way rely upon them until the appeal is heard and determined. The point we are making, Your Honor, consider the victim's position. A loss of 300 plus million public money is such a matter of great public importance, and therefore it should not be trivialized. Let the accused persons pay the price they must pay. That's all. Yes. Submission is of no value. There is something that looks like a list of graduation here.
You know, with tremendous respect, it cannot be little. It cannot be little.
Yes.
I ask you not to comment on that. Those are issues that we perhaps we cannot verify.
Yes, Your Honor, the comment I was going to make is the form.
Which form?
The form of the document on questions of signature, dating, and its veracity. That's all.
Which form are you talking about?
I'm talking about a big document here bearing a list of so many people who are alleged to be students of certain.
The one who says after the sentence.
Yes, list of beneficiaries. No, at the top it reads list of yes, beneficiaries, then other dependents. I hope you are looking at the same document. Yes. So we'll be urging. Yes, Your Honor, we are saying.
So on the offences under their second, the court may not have much discretion, as the fines are provided for, and the stipulation, particularly section 48 and 48(1) and 48(2) are premised on figures, and those figures can only be ascertained whether they are in each case depending on depending on the circumstances. Mr. Kubasu urged this honorable court to find in the first and second count a figure that he gave of 100,000 in each count, and he cited a court of appeal decision. The figures that were posted, and also while being guided by the authority that was cited, the court will agree that the proposed fine is within the fine ranges of this court. The court has however taken into account the ages of both accused person and the circumstances under which the offense was committed. The court finds that the offenses are serious, and the accused persons took advantage out of a dire situation where the Kenyans were faced in the danger of hunger, and maize was required to be important to save them from starvation. This court finds that a huge amount was lost in the process, and is therefore called to give a deterrent sentence. So the accused persons are sentenced as follows. In count 1, the law provides for a sentence for imprisonment for 3 years. But since the proposed amount appears reasonable to this court, the first accused is fined Kenya shillings 100,000 in default to serve 1 year imprisonment. In count 2, the law provides for imprisonment for a period of 7 years. However, taking into account the age of the accused person and being a first offender, she's equally fined Kenya shillings 100,000 in default 1 year imprisonment. Count 3 has 2 limbs. That is under section 48(1)(a) and section 48(2) on the quantifiable amount that was lost. So in respect of section 48(1)(a), where the proposed fine is not exceeding 1 million and a period not imprisonment for a period not exceeding 10 years, the accused persons are sentenced as follows. In count 3, the first accused is fined Kenya shillings 500,000 in default to serve 3 years imprisonment. The second accused is fined 500,000 in default to serve 3 years imprisonment. The third accused is fined Kenya shillings 500,000. The first and second accused are hereby ordered to pay, and in default, they will each serve a period of 3 years. So under section 48(2)(b), the NCBB lost a quantifiable amount, and each of the 2 accused persons under the law, which provides that the fine imposed to be equal 2 times the amount lost. In this case, the NCBB lost 297,086,505 times 2. So the first accused is fined Kenya shillings 594,175 default to serve 7 years imprisonment. Second accused, similar amount, default 7 years imprisonment. The third accused, same amount. The first and second accused are directed to pay. In default, each of them will serve a further 7 years imprisonment. Count number 4 under section 48(1). First and second accused are each fined 500,000 in default 3 years imprisonment. The third accused is fined similar amount, and the first and second accused are directed to pay. If they do not pay, they shall each serve 3 years imprisonment. Equally under count 4, the complainant lost a quantifiable amount, which is 13,364,671.40 times 2. So the first accused is fined Kenya shillings 26,729,342 and 80 cents in default 7 years imprisonment. Same amount for the second accused, default similar period, and the third accused is fined same amount, that is 26,729,348 and 80 cents. The first and second accused to pay. In default of them paying that fine, they shall serve a further 7 years imprisonment. In count number 5 under section 48(1)(a), first accused, second accused are each fined Kenya shillings 500,000 in default to serve 3 years imprisonment. The third accused is fined similar amounts, and the first and second accused are directed to pay. If they do not pay, they shall serve a further 3 years. Equally in count number 5, NCBP lost a quantifiable amount under section 48(1), sorry, 48(2)(a), which was USD 24,032 times 2. Therefore, the first and second accused are fined USD 48,064, similar amount 48,000 in default, 7 years imprisonment. The third accused is fined similar amount. The first and second accused are ordered to pay. If they do not pay, they will serve a further period of 7 years. Under section 48(2), out of the offense, the first and second accused drew a benefit that is equally quantifiable, and the law provides twice the amount that they each benefited. So in that respect, the first accused is fined Kenya shillings 80 million in default to serve 7 years imprisonment, and the second accused is fined Kenya shillings 100 million in default to serve 7 years imprisonment. They have a right of appeal within 14 days. And the second accused, being a public officer, the conviction to be served the Speaker of National Assembly and the Parliamentary Service Commission for purposes of compliance of Section 63. 1, pending any outcome of any appeals. If the fine is paid, the court hereby makes further orders as follows. Out of the fine paid, out in count 3, NCBP shall be compensated amount equivalent to what was lost from its KCB account. In count number 4, similarly, the fine is paid, the National Bank, NCBP will to be compensated to the extent of the amount lost from its NBK account as per count 4. Similarly, if the fine is paid immediately, an amount equivalent to the amount lost from Cooperative Bank be paid to NCBP. If the fine is not paid or the amount received is not sufficient for the compensation, the complainant shall be at liberty to take civil action for recovery. 14 days, right of appeal explained. Yes.
Number 1, we are applying for certified copies of the proceedings and also a certified copy of the judgment and the sentence notes. However, in view of the exception of the capital of this matter, and we want to make the appeal by tomorrow, we are also applying that we have the option of having handwritten certified copies of the judgments.
The judgment is typed.
Oh, that's great. And particularly the notes, the sentencing notes. So we can get it now. We can get the judgment now.